Thank you very much for joining us this morning. My name is Neil Ward, a partner here at Mills Reeve Solicitors. Welcome to our first of two webinars that we're doing. So today and then the same thing this time tomorrow. So in two parts. This is a session today. We're going to be talking about the consultation the government has launched with regard to the changes to the Mental Capacity Act, in particular the draft Code of Practice that has now been released along with various regulations and a consultation document. Today, I'm joined by three colleagues, Katrina McCrory, Garrood and Lottie Hartescu, who are going to talk through the changes that are proposed to be made to the Code of Practice outside of the liberty protection safeguards. The tomorrow's session, same time tomorrow, will be focusing on those changes to the liberty protection safeguards and the introduction of those regulations which are going to replace the current deprivation of liberty safeguards. Inevitably, this is a big topic, and for anyone who's looked at the consultation document, there are some quite meaty documents that the government has released. So there's quite a bit of material. So it's not the intention of this webinar or tomorrow's to cover everything in huge detail, but really rather to give you a flavour and to point out maybe the main issues that are going to be changing or proposed to be changing, and to give you some time to have a think about whether you would like to respond to the consultation. We'd certainly encourage all of our clients to do so. The consultation is open until early July, so there is still time to do that. And the government is very clear in the consultation documents, very interested in people's views, and so be pleased to hear those. So that is really the purpose of these webinars. Because we've got quite a bit of material to go through, we will take questions at the end. So if you do have a question, please pop it in the Q&A box. And when we've finished the short series of talks, we will look to try and answer as many of those as we can. Each of the three speakers will speak for about 10 minutes. So that should take us about half an hour, leaving hopefully 10 or 15 minutes to answer questions at the end. This session is being recorded, and after these sessions, you will receive an email with a link to the recording, as well as a copy of the slides that are being used today. So I think that's everything from me in terms of the practicalities, in which case I will hand over to the first of our speakers, Katrina. So over to you, Katrina. Thank you very much.
Thank you, Neil. Good morning, everybody. So Neil sort of set out what we're looking at today. The first thing I'd like to just point out on a practical level is that we now have one code of practice. So just if you're looking for two codes of practice relating to the MCA and the LPS, they've both been integrated into one set of guidance, which I think is from my point of view really helpful, because obviously all the LPS principles come from the fundamental principles of the Mental Capacity Act. So I think that's a very useful start. The other thing that I'd just like to say as a start off is that the code is statutory guidance. So what we have in the code isn't actually any new law other than the issues relating to LPS, which we'll be looking at specifically for tomorrow. The guidance is guidance, but it also brings up to date with case law where we are at the moment with Mental Capacity Act. So there shouldn't be anything other than the LPS part of this that is fundamentally different or changing the law. It's just putting the current law and the new LPS procedure into the guidance that the draft guidance that we now have. Can I just have the next slide, Debbie, please? So the area I'm looking at is the role of the Court of Protection. So again, one of the first things on a practical level to look at when we're looking at the chapter relating to the Court of Protection is, with the old guidance, there was a chapter relating to the Court of Protection and also court-appointed deputies. There are separate chapters relating to that now. So the old guidance had one chapter, now we've got separated chapters. Again, I think that is helpful. The old guidance, it is quite different if you look at the new guidance, and I think it is quite a lot clearer than it was before. So there are specific headings, and it leads you through what the Court of Protection can do and can't do. So in terms of the description of the Court of Protection powers and declarations and decisions, it's a clear heading about what the Court of Protection can do. So, for example, the Court of Protection can make decisions relating to capacity, interim declarations while evidence is being gathered, and also looking at proposed action if that's lawful, for example, if there's fluctuating capacity. So nothing particularly new there, but it's much clearer about how it's set out. Also looking at decisions that the Court of Protection can't make. So obviously, if P has capacity, then the Court of Protection is not authorised to make decisions on their behalf. There's also some specific areas that the Court of Protection can't get involved in. For example, marriage, authorising or recognising marriage abroad. And also accepting or refusing treatment if a patient is detained under the Mental Health Act, and Sarah will be looking at a chapter specifically on interrelation between the Mental Capacity Act and the Mental Health Act. So again, the new guidance looks at where you need to go to court. So I think it's helping people navigate decisions about actually, do we need to go to the court or not? So it's quite specific about where you do need to go to the Court of Protection. Again, for example, where there are property issues and there isn't any other route to take, so there won't be a lasting power of attorney, for example. So there might be issues relating to tenancy that needs to be signed, and the only ability to get the authority to do that is through the Court of Protection. Wills, for example, with somebody without capacity, the Court of Protection would be needed. Sorry, the light just went out. Would be needed for that. And also medical treatment cases where it's life-sustaining treatment at the end of the life, and it's a difficult balancing exercise for those hard end-of-life decisions, or there is a particular dispute about it. So those again, the guidance is helpfully quite clear. You do need to go to the court. There's an interesting point at note 82, which does again helpfully make it clear that those cases where you need to go to the Court of Protection, it doesn't refer to cases where actually the medical team just aren't offering or can't give that particular treatment. If there's a challenge to that, that might be a judicial review, or you might need to go to the court, for the High Court to sort of authorise that decision. But the Court of Protection relates to when there are options. And again, the guidance brings us up to date with the case law relating to options. There's a clear case, 2017 case of Rien, which the Supreme Court has made a decision that the Court of Protection can't interfere in public bodies' decision-making in terms of options. There is, however, quite clear guidance that it's paragraph 7.17, if you're interested. It does set out that although the Court of Protection can't interfere in public bodies' decision-making on options, it can test that decision-making. So, for instance, I've recently had a case where the Court of Protection judge in a Court of Protection case did make an order that the public body needed to set out a statement relating to the public law decision, so that then, if necessary, there could be a challenge as a judicial review challenge. So it's just interesting how the guidance has kept up to date with that, and we'll have to just wait and see how Court of Protection judges deal with that. So there's also a section about where Court of Protection applications may be required, and again, that's quite clear in terms of property cases where there's a disagreement, medical cases where there may be an interference with somebody's Article 8, right to private life. So there's the sterilisation, organ and donation types of cases that were previously referred to in the previous guidance. There's also an interesting section about this weighing up of trying to resolve things and also a delay in bringing cases to the court. It gives some sort of assistance, but basically it's, don't leave it too long, but also do try and resolve it. So that's about as helpful as the guidance can be. But anyway, it is in there to recognise that's an important issue. Next slide, please, Debbie. So there's also a new section, obviously, about the rule of the Court of Protection and Deprivation of Liberty. So the first thing is that the Court of Protection rules allow any person to apply to the Court of Protection without permission regarding the LPS, and that can be P, the appropriate person who's supporting P through the LPS process, or the IMCA. So that's an important principle, and what the court can do is vary or terminate, or direct a responsible body to vary or terminate. So that's again important, because the LPS, what the court is trying to do is limit its own involvement in decisions that the responsible body can make. So there's, again, it's a sort of trying to push things down to LPS, but also the Court of Protection being involved. So another area, sorry Debbie, can we have the next slide? That I think runs throughout the whole of this guidance is this interrelation between, yes, you can go to the Court of Protection, it's really important for your Article 5 rights, but you really need to try and sort out ways of settling disputes. So there's a specific chapter relating to that. I won't go through it in any detail, but it has a lot of information about advocates, when you should use an advocate, mediation, and the complaints process. Difference in getting it right about what is a best interest dispute and what is a complaint. But again, making that distinction, you can always go to the Court of Protection. It also has interesting and helpful information about where legal aid can be granted, and also information about legal help, which is helpful. Next slide, please, Debbie. So again, there's a new section really about disputes in the LPS. The principles behind this is that the responsible body needs to make it really clear to everybody about how you can bring up issues and complaints and things that you're unhappy with throughout the LPS process. And they need to publish all the publish that information, but also the right of somebody to bring an application to the Court of Protection. So once again, it's just getting the balance right between, yes, you can go to the Court of Protection, you don't need permission, you can get legal aid, but there's all this other process that you really need to try first. So that's, again, it's this sort of fundamental theme in terms of the new guidance about trying to get that right. Next slide, please, Debbie. And lastly, the area I'm looking at is how the Act applies to children and young people. So there's clarification of the wording. So the guidance talks about children, and that's in people under 16, and also then young people who's between 16 and 17, which is different language to the Children Act, which just groups everybody together and is a child under 18. It sets out where the Mental Capacity Act can relate to young people and where it can't. It's also got an interesting section within it which does make it clear about how decision making can be used for young people and whether that should be under the best interest framework or under the common law relating to a decision of a parent, and when that should happen, which is really up to the individual, but you need to be very clear which legal process you're going to use. There's interesting guidance as well about when the LPS can be applied. But that's it in a very, very quick, probably too long nutshell. And I'll pass over to Sarah now.
Thank you, Katrina, and good morning, everybody. I'd like to carry on, please, with this update to some of the existing chapters of the code, and I'm going to start with chapter 3, which is about how people can be helped to make their own decisions. Casting our mind back to the original or to the implementation of the Act way back in 2005, one of the original aims was to ensure that this legislation was enabling and empowering, so putting people at the very heart of the decision-making process. The revisions to the proposed revisions to chapter 3 really give that more emphasis, and additional paragraphs have been added to try and explain how people can be supported to make their own decisions so far as possible, and where they're not able to make their own decisions, then to play as big a role as possible in the decision-making process. Paragraph 3.4, though, makes it very clear that the purpose of the support is to enable the person to make their own decision. So where the person offering the support maybe has their own view on what the best decisions should be, it's important that they don't use that view to bring undue influence on the person concerned. And the draft code highlights the need for professionals to be vigilant about the use of coercion or undue influence. And it sets out some practical examples about the sort of way that influence can be brought to bear, and professionals need to be mindful of that. A section has also been added to stress the importance of involving the person throughout the LPS process, where an authorisation under the LPS is being considered. And the new code sets out the sets out the sort of different key decisions that will need to be made and how to ensure that the person is involved throughout that process. So at the outset, it's thinking about the decisions around what might be in the person's best interests and making sure that their wishes and feelings are taken into account. When the assessments are being made, it's ensuring that the person is involved and participating, usually through the appointment of an appropriate person or an IMCA. And then once the authorisation is in place, it's ensuring that the person is able, has support to enable them to decide what to do next if they are unhappy with those arrangements. Next slide, Debbie, please. So the reference to the IMCA there brings me neatly onto my next section, which is to look at the changes that have been made, or proposed changes that have been made to the chapter dealing with the role of the IMCA. The changes have been made, I think, in part because obviously the original code is now over 15 years old, so it's probably not appropriate to refer to an IMCA as a new role nowadays. But the chapter has been updated, obviously, to reflect the fact that the IMCA, as before, has the same rights to challenge decisions as any other person caring for P. But the new code now refers explicitly to the various ways in which disagreements can be dealt with, and which Katrina has already touched on and are referenced in the draft amendments to chapter 24. This section has also obviously importantly been amended to explain the role of the IMCA in the LPS process. The duty is on the responsible body to ensure an IMCA is appointed as soon as the LPS is triggered, where they are not satisfied that there is an appropriate person to support and represent P, and either P has capacity to make a decision regarding the appointment of an IMCA and requests to have one, or P doesn't have the capacity to make that decision. The responsible body would then be required to appoint an IMCA unless they feel it's not in the person's best interest, and the code makes it clear that such circumstances are going to be pretty few and far between. The role of the IMCA in the LPS is a continuous one, so they're appointed at the beginning of the process. And the idea is that the same IMCA will, so far as possible, continue to support and represent the person once the authorisation is in place. Next slide, please, Debbie. In order to ensure that the IMCA is best able to support the person, the idea is that the responsible body will provide them with copies of all assessments, keep them informed throughout the process, and notify them of the outcome, including providing them with a copy of the authorisation. It's for the IMCA to decide how best to support the person, and importantly, where the person is not able to express their wishes and feelings, the IMCA should attempt to ascertain those wishes and feelings from speaking to or observing the person, from speaking to those involved in caring for the person, and looking at records. In part, the role of the IMCA is to represent and support the person in their relationship with the responsible body through the LPS process, and they should seek to ensure the best outcome for that person, which includes encouraging the responsible body to consider all options. If an agreement can't be reached, then an IMCA can request that an approved mental capacity professional becomes involved, not necessarily as a formal mediator, but as an additional line of scrutiny for the process. And they can also assist the person to make an application to the Court of Protection, as Katrina's already mentioned. Next slide, please, Debbie. So the last section I want to consider is the amendments to the code, which deal with the relationship between the Mental Capacity Act and the Mental Health Act. This is a great example of a section where there's obviously been a lot of case law, and the code has been updated to try and capture some of that case law and some of the changes in legislation. And as a nod to how frequently the thing changes, the new MCA code highlights that that it in fact will supersede the equivalent content in the current Mental Health Act code until the Mental Health Act code is updated. Since the original code was in place some 15 years ago, obviously there's been a number of changes to the Mental Health Act, including the creation of community treatment orders, and this code obviously reflects those changes and provides some practical scenarios to explain how the interface works. And obviously by interface we mean where the Mental Health Act and the Mental Capacity Act sort of meet, so either they can run in parallel or there is a genuine choice between the two. As I've said, there are a number of practical scenarios. One thing I think I would urge people to have a think about is to look at some of those scenarios and to think whether or not they do give a good reflection of maybe difficulties that you might have encountered over the past few years in this kind of thorny issue of the interface. And if you feel that perhaps those examples are not realistic or not gritty enough, do please feed that back through the consultation process. Next slide, please, Debbie. But in a nutshell, dealing with the LPS and the relationship with the Mental Health Act, the code has been updated essentially to reflect the decision made in the case of AM and South London and Maudsley about when to choose the MCA and when to choose the Mental Health Act for a patient who needs detention in a hospital for mental health treatment. It emphasises obviously that you can't use the Mental Health Act and the LPS together to detain in hospital, so it's one or the other. And there is a detailed analysis in the code which reflects the case of AM as to whether to choose the Mental Health Act or the LPS. Essentially, where you have a person with capacity who can make a decision regarding detention for their mental health treatment, then the LPS is not available. Similarly, where you have somebody who lacks capacity but is objecting, then again the LPS will not be available. But where you have somebody who lacks capacity, is eligible to be detained under the Mental Health Act and is not objecting, then you do have, in theory, a genuine choice. And the code sets out some of the factors that ought to be taken into account when making that decision, including the need to consider which is the least restrictive way of achieving the proposed assessment or treatment. The code also goes on to look at how the interface can work in the community. So, for example, where somebody is subject to a community treatment order, it looks at how you can run the LPS in parallel. So that's a quick whistle-stop tour of what I appreciate is quite a complicated area. And I'll hand over now to Lottie.
Hello, everybody. The code also gives very useful guidance on the definition of capacity, the way capacity is assessed, and also the way best interest decisions are taken for P, which is what I will be talking about in the next few minutes. In terms of how the Act defines a person lacking capacity and how this is assessed, the presumption of capacity still remains, but there is a change in the order of the test of capacity. And this is mostly to highlight the difference between considering somebody's capacity and actually assessing it. Now, that might sound a lot easier than it probably will be in practice. And just to clarify, the idea of considering somebody's capacity means asking whether there is a proper reason to doubt that that person has the ability to make a capacitous decision, whereas assessing is talking more about the specific terms of assessing somebody's ability at an X point to make X decision. The test of capacity as it looks now starts with the question, is P able to make that decision with support if required, which means is P able to understand, retain, and weigh the relevant information? If the answer to that is no, we go on to the second question, which is there an impairment or disturbance in the functioning of the mind or brain? And the third question is whether P's inability to make the decision is directly caused by the impairment or disturbance in the functioning of the mind and brain. Next slide, please, Debbie. The code also gives some useful indicators on how to assess specific instances of capacity. So we're talking about fluctuating capacity, and the code makes a difference between assessing somebody's capacity when they have to make isolated decisions, so one-off decisions, as opposed to repeated decisions. And there is advice in there about potentially delaying an isolated decision to the point when somebody would be most likely to regain capacity. And in terms of repeated decisions, it talks about allowing a broader amount of time to assess capacity. If in this broad amount of time, there is indication that there are very few instances when the person would have capacity to make a decision, then potentially that would weigh towards them not having capacity. It also talks about assessing capacity in people with executive dysfunction, and there it talks about evidence of a repeated mismatch in what that person is saying and what they are doing in relation to the capacitous decision. And the code also gives us guidance on the idea of assessing capacity retrospectively, in which case the presumption sort of turns on its head. Now, in terms of the definition per se, the guidance tells us more about how to identify a disturbance or impairment of the mind and brain. And that has to have a proper basis, but it doesn't have to be a formal diagnosis. So it is quite wide-ranging, and it could include physical disabilities, learning difficulties, illnesses related to age, or even temporary conditions such as intoxication, drunkenness, unconsciousness. The code also talks about the link between somebody's inability to make the decision because of the impairment in the functioning of the mind or brain. And the code makes clear that it doesn't have to be something that affects their capacity to make the decision, but it must render the person completely unable to make the decision altogether. The reason for which this definition has been changed is, as my colleague Sarah was saying, because now there is an added emphasis on the support for the person and on empowering them to be able to make the decision for themselves. So question 1 now takes precedent, because the code wants to discourage the automatic assumption that because the person has a condition, they cannot make a capacitous decision. And now there is added emphasis on the information and how P should receive the information in order to be supported to make their decision. So the code does set out a list of things that a capacity assessor should take into consideration. The most important of them all being that all practicable steps should be taken to try and support P to make their decision. And that includes giving them all of the information in a way that is accessible to them and in the way that they could best understand it. And the code gives guidance on a process of stopping within the first 5 minutes of assessing capacity, checking P's understanding and repeating this throughout. Next slide, please, Debbie. So in terms of how to assess how to make a best interest decision for somebody, it is still important to say that a best interest decision is only relevant after all practicable steps have been tried and failed, and P cannot be supported to make the decision for themselves. Again, there is here added emphasis on the person's wishes and feelings, and the code has a duty to take all the code establishes a duty for the person making the best interest decision to take all reasonable efforts to find out whether P has expressed views in the past that should inform the decision to be made. The code also sets out some factors which might or must always be considered and applied on a case-by-case basis when making a best interest decision. So this decision can't simply be on age, appearance, or behavior. All relevant circumstances about P need to be considered, including cultural background and any sort of information you might have about them. Every effort should be made to enable and encourage P to take part in making that best interest decision as much as possible. And P's past and present wishes and feelings are at the crux of it. They are more important than always. And there is a suggestion that that would probably be best achieved by speaking to P, but also consulting those around him. The code also gives some instances of where we would need to appeal to the court in order to make a best interest decision, as Katrina has said before, but just to touch on these quickly, in situations where you're assessing a best interest and there are disagreements between either the family members or the practitioners, or maybe there is a disagreement of medical opinion, would be instances where you might think of applying to the court. Of course, there are also instances when we would need to go to the court, and that is in the case of making a best interest decision about sterilization or organ donation. And another thing to bear in mind is that whereas before, in terms of making a decision to withdraw artificial nutrition and hydration, there was an obligation to go to the court, this is no longer the case. Can we move to the next slide, please, Debbie? We are also speaking about important decisions. So the code adds this idea of important decisions, which are decisions about life-sustaining treatment, moving to long-term accommodation, and contact restrictions. These are decisions that affect somebody's life heavily. So special considerations need to be given to them when making them as best interest decisions, and especially when recording them. So that will be a very big difference in terms of how an application will look in the court. So further emphasis will need to be had on P's wishes and feelings. There needs to be a clear justification recorded if the decision is something that P had expressed in the past wishes against it. And detailed records of best interest decisions need to be kept, and these should include things like steps made to involve the person in the decision, an explanation of why it is believed that they lack capacity to make the decision, steps taken to ascertain wishes and feelings, and again, information about who was consulted. All of those are very, very important. Next slide, please, Debbie. So chapter 6 of the code also speaks about protections for those who provide care and treatment to somebody who lacks capacity. And the code contains these protections from liability for people like family members or carers or social care staff, school staff, if we're speaking about somebody in education, so they can act in connection to P and provide treatment without risking liability. These protections are available only if the person providing the support and treatment has taken all reasonable steps to establish whether the person lacks the relevant capacity. They also have to have a reasonable belief that the person lacks capacity and believe that the act they are doing is in this person's best interest. Now, the idea here is in the code that it's been reinforced that the consultation process comes heavily into this. And there are isolated circumstances where in case law, where somebody's family had expressed a wish that wasn't taken into account by hospital professionals. And in that case, they lost the protection under this Chapter 6. And it is also worth mentioning that these protections are not effective against negligence. Next slide, please, Debbie. So with that, that was our presentation. Thank you so much for listening to us. And now I will hand back to Neil for the Q&A.
Thank you, Lottie, and thank you, Katrina and Sarah. So as we said, a real whistle-stop tour. There is a lot of information out there. If it helps, the code itself is lengthy. It's over 500 pages long, so not something just to casually flip through. But the government has also produced a really helpful consultation document, which is a lot shorter. I think it's about 25 pages long or so on. And what that does is very helpfully summarize a list, a sort of bullet point list of changes to each of the chapters that are being proposed, and also includes the consultation questions. So if you are minded to get involved and respond to the consultation, which we certainly would encourage you to do, then that might be a good starting point. Okay, so as I said before, please do feel free to send some Q&As. We've got a couple already. If I could just start with one, Katrina, for you, I think. This, I think we can use as a bit of shameless advertising for our session tomorrow, because I think it will be dealt with in a lot more detail tomorrow. But a question's come through on your presentation about the role of the Court of Protection and the deprivation of liberty, and specifically what is the responsible body and who will be making those decisions.
Thank you. Yes, so the responsible body, that's a new bit of terminology, and it will be covered in tomorrow's presentation. But it's the person or the public body that is responsible for the LPS process. So that's now going to be clinical commissioning groups and the local authority. But it is the wording of responsible body is used more widely in the guidance than that. In the organisation that's making the application. It doesn't have to be a public body making the application to the Court of Protection, but in the Court of Protection chapter there is quite a helpful set of guidance about who would be if it was a public authority, who would be the public authority to make the Court of Protection application. And that's actually quite helpful, because that can be quite a tricky situation to navigate about what, when P is receiving care from the local authority and the NHS, or the commissioner and a provider of the NHS, it's in navigating who needs to make an application, or whether it's P themselves or the family if there's a dispute. So I would recommend that you have a look at that, because that's more than we had before. It's not always an answer, but it does give you some assistance.
No, thank you. Yeah, that is true. It is often a contentious area. Thank you very much, Sarah. I just wondered, a lot of your presentation and indeed detail in the code, it talks about the role of the IMCA and the need to support P as much as possible. I think it's probably fair to say that the IMCA service across has been a bit variable over the years through various sort of, I suppose, funding issues and sort of criteria and that sort of thing, and it has been a bit patchy sometimes. Excellent service in some areas, difficult to access in others. Do you think there's going to be a desire and possibly resources to be able to make that service a bit more sort of widely, well, it is widely available, but a bit more easily accessible maybe for everybody?
I would hope so, Neil, because certainly, as I mentioned, there is so much more emphasis, I think, in this new code about the importance of putting, P at the very heart of all of this. And we know it was the original intention, but there's more emphasis on that. And I think obviously the IMCA has got a really important part to play in that. I mean, one of the things I didn't mention in the presentation, but there is also scope for an IMCA to be appointed alongside an appropriate person in the new LPS process. So if the appropriate person themselves feel that they need support with that, the IMCA should be available to do that. So I think obviously it's a role that's evolved over the last 15 years. You know, as I said, it was a new role at the start of the Mental Capacity Act, and so it's a role that's developed, I think, has had some success, and I would hope that there will be funding to match what I think is an important part in helping to put P at the centre of all this decision making. Yes,
yeah, thank you. Lottie, you mentioned in your presentation right at the beginning about the fact that the change of the order of the capacity test. So the first question now is P able to make a decision, and then you go on to consider whether there's an impairment, and then is that linked to that inability to make a decision. Do you think that's an important change, or do you think that's sort of window dressing really of in terms of how people practically apply these changes?
I think it's going to be quite an important change in how capacity is assessed, and also in all of the documentation that follows that. Throughout these new guidances, P has been at the center of every single assessment, and I believe a lot more evidence is going to be required about consultations in terms of best interest, and about what sort of actions have been put in place to make sure that the person is as supported as possible to make a decision if they can. So I think documentation about all of the conversations around that, and clear documentation in terms of assessing somebody's capacity in a situation where it might be a trickier question, will be very important in the future.
Yes. And I think sometimes it's true to say as well, isn't it? Sometimes, particularly in difficult decisions, it's very easy for professionals to sort of focus on the outcome that's wanted, and then sort of almost making a best interest decision there, and then sort of working backwards from that. And so hopefully that change of emphasis may help people just really focus on the decision first, and then if they can't make that decision, then is there an impairment? Sarah, just a further question for you is that the current guidance has a best interest assessor and a mental health assessor to make sure that the P is detained under the Right Act or Mental Health Act. How do you think that might change without the mental health assessor role, do you think?
I think that might be something I'd need to think about, Neil. I don't think I can provide you with an answer to that off the top of my head. I think that's more related to the liberty protection safeguards, isn't it? And I think something that
something we might talk about in more detail tomorrow.
Yeah.
I suppose the only thing from what you've said today in terms of the overlap with the Mental Health Act, do you think that there is still going to be what I think was referred to in the case law as the primacy of the Mental Health Act? Do you think is that still going to be a concept, do you think, that's going to carry on?
No, I don't read anything in this draft code of practice that suggests that the Mental Health Act is considered to have primacy. In fact, it seems to talk very much more about the kind of a balancing act. I mean, personally, I think I would welcome a bit more guidance, I think, almost in the code of practice on that issue, because I think it is really quite a tricky one. And whilst it talks about least restrictive, trying to balance out what's the least restrictive, it then goes on to say, well, both acts endeavour to do so in the least restrictive way. So that's some help and no help, if you like.
It is.
So
and
I
they
think
are some
it's
of the
a very
most
tricky decision.
It is, and they are some of the most challenging cases we see, aren't they? And
Yes.
particularly also patients that maybe have do have perhaps a mental health issue, but also have a physical health issue, and a deterioration in their physical health can then trigger a problem with their mental health, and vice versa. And so that those areas are exceptionally complicated. And I would certainly echo what you said, Sarah, in your presentation, that that everyone who's listening, if you are responding to the consultation, looking at the little examples, the vignettes that they give throughout the code, and are those helpful? Are they, to use your word, gritty enough? Are they, going to answer the questions? Because, of course, once the code has been signed off and, finalized, we'll be stuck with it. So I think that is a really important point. And there is probably very few more complicated areas than the interaction between the Mental Health Act and Mental Capacity Act and all its various forms, both in terms of decision making, but also in deprivation of liberty. So I think to answer the very specific question that was raised, I think that is something we will be looking at tomorrow. But on a more wide point, I think it is important. If you think that there are difficulties with really drilling down to the detail and how is this going to apply in practice, that is precisely the purpose of the code, isn't it? It is there to, as Katrina said, it is not statute, but it is obviously good practice, and it is certainly something we should be following. So if we think it's not getting it right, now is the time to input into that. Okay, well, I think we've run out of time. If there are further questions, I'm conscious there are a couple of questions we haven't been able to get to. We will respond to those. As I mentioned, shortly you will be getting, by shortly I mean days rather than hours, I think, a copy of this recording and the slides. Please do get in contact with us. You've got our contact details direct if you've got further issues you want to raise. Other than that, I encourage you, if you can, join us same time tomorrow to pick up part 2. We would love to see you and to take you through that. Other than that, I think that's everything, and thank you very much.